Good morning, good afternoon, and welcome. I'm Ellie Kemeter with Foley and Lardner, and I'm pleased to welcome you to today's NDI Checkpoint Web Conference. In this program, we address the 2015 Proxy Season Preview. I'd like to take a moment to introduce our program speakers for today. First, we have Josh Agin. Josh is a senior counsel with Foley and Lardner and focuses his practice on assisting public and private companies in the area of executive compensation, employee benefits, corporate transactions, and security law compliance. Second, we have Rick Grubau. Rick is a senior vice president of D.F. King, a leading full-service proxy solicitation and corporate financial communications firm. Rick primarily advises corporations and shareholders involved in complex shareholder transactions, specializing in corporate control situations such as proxy contests, mergers, and unsolicited tender offers. Next, we have Pat McGurn. Pat serves as special counsel at Institutional Shareholder Services, the world's leading provider of proxy voting services and corporate governance research. ISS recommends votes on ballot issues for more than 39,000 shareholder meetings across 100 markets around the globe. Lastly, we have John Wilson. John is a partner with Foley and Lardner and focuses his practice on mergers and acquisitions, corporate financings, and security law matters. He represents Fortune 500, middle market, and emerging and public and private companies in a variety of industries, as well as investment banks and venture capital and private equity funds on their transactional and corporate matters. Before I turn the presentation over to our speakers, I'd like to go over a few housekeeping items. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit written questions during the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to written questions at the end of the program, time permitting. The webcast console you are looking at can be completely customized. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience technical difficulties during the presentation, please visit the webcast help guide by clicking the help button below the presentation window, which is designated with a question mark icon, or by clicking the On24 support team link in the resource list. The PowerPoint presentation will be available on our website at Foley.com in the next few days, or you can get a copy of the slides in the resource list widget today. As a reminder, today's program is being recorded and will also be available on Foley's website in the next few days. Foley will apply for CLE credit after the web conference. If you did not supply your CLE information upon registration, please send an email to Ellie Kemeter at ekemmeter@foley.com. To be eligible for CLE, you will need to log into the On24 session and answer a polling question during the program. As a final note, those seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form in addition to completing the polling question that will appear during the screen. A 4-digit code will be announced during the presentation. Please email the form and the code to Ellie Kemeter at ekemmeter@foley.com immediately following the program. And now, I would like to turn the presentation over to John Wilson.
Thanks, Ellie, and thanks all of you for attending our presentation on overview of the 2015 proxy season. Hopefully you will find it timely, but as I think we are all coming to know these days, proxy season, for better or worse, is now year-round activity with shareholder engagement and carefully making decisions throughout the year at board meetings and corporate governance and executive compensation matters. We have a lot of ground to cover here in an hour today. First, we are going to talk about shareholder proposal trends, how they turned out last year, and what we expect to see this year. We'll briefly touch on the impact of increasing shareholder activism. We'll talk about say-on-pay and executive compensation disclosure trends. We'll hear from Pat McGurn in particular on voting policy changes from proxy advisory firms such as ISS and Glass Lewis. And then we'll conclude with some trends and actions that some companies are voluntarily doing to enhance their corporate governance and say-on-pay votes. Turning to shareholder proposals then, the first one we're going to talk about is Proxy Access shareholder proposal. It wasn't as big of a proposal last year, but it's currently been in the headlines as a result of the New York City pension funds who have launched a campaign and submitted this proposal at 75 different companies. They have styled it similar to the SEC rules that were put into place but then turned over by the court. where a shareholder or group of shareholders who owns 3% for 3 years can nominate a director and have access to the company's proxy statement for that. In the prior years, this type of proposal at the 3% and 3-year level got the greatest support from shareholders. Last year, there were several where received the majority of the votes cast, high of 65%, low of 44%. And so we expect this to be a real proposal this year. There has been, though, a key development. Last week, Whole Foods was faced with this proposal at the 3% 3-year level and decided to put in place its own proposal for 9% and 5 years and put that on the ballot. And last week, the SEC granted a no-action letter that Whole Foods could exclude the 3% 3-year proposal, which will make things interesting here. I'd ask Rich Grubaugh if you could comment. What do you expect to see on this in 2015, and how are companies going to come out? Will they fight it, settle it, or perhaps do counter proposals like Whole Foods is doing?
Yeah, thanks, John. Yeah, I think obviously the stats, for the last few years, we've seen these proposals come in at very, different levels, 1%, 2%, 3%, and the shareholders have, come out that the original SEC level of 3% 3 years is sort of the acceptable level. So the majority of the institutions are supportive of that. So right now, the New York City has submitted 75, plus there's a number of additional ones. So we could see over 100 of these proposals this coming year. So really, as you said, 6 out of 10 of the 3% 3 years passed last year. So the odds are not in the company's favor. So really, I think what many companies are contemplating right now is coming up with something similar to the Whole Foods strategy. Whether or not the 9% 5 years obviously is not going to win any institutional support, but there may be a level that some institutions are going to accept that is greater than 3% 3 years, and so many companies may be coming out with a 5% 5 year, and obviously that will allow for that. The institutions will support that because that's the only that will be the only proposal on the agenda. But then we'll just see. We're just starting the private ordering process. So if the following year another 3% 3 year comes, we'll find a happy medium, and where that's going to be, we don't know yet. But this is going to take several years. But this is just the beginning of private ordering.
Thanks, Pat. Rich, let's turn it over to Pat. What do you expect from an ISS perspective? Any changes in this area, and how do you see institutional shareholders viewing this?
Yeah, our approach remains the same. It's a case-by-case analysis for us, I think. But obviously, if you look at our recs over the last couple of years, we've supported the lion's share of the 3% for 3-year proposals. And I guess I differ a little bit from Rich about shareholders sort of automatically supporting something like 5 for 5. I think a lot of investors viewed the SEC's rule as sort of a balancing act between the issuer and investment communities. So a lot of the compromise actually took place in the process of submitting comments and going through the rulemaking process at the SEC. And I think that's why you've seen those proposals sort of float up to the top. I know there are some activists that would actually like a much lower and shorter time length to the holding period and the ability to even nominate more directors. But the idea that sort of 3% for 3 years is the opening bid and this is an open negotiation, I think that might be some faulty logic, and boards may ultimately find themselves being targeted with no-vote campaigns, I think, as a result of sort of switching from that 3% for 3-year standard. So I'm just not as sure as I guess Rich was that there's a lot of room to negotiate here, but We'll have to see how this issue plays out over the course of the year. We're expecting that there'll be some meaningful engagement between the proponents of these resolutions, especially obviously the New York City funds and some of the companies that have been targeted with them, but we'll have to see how that plays out. But I think it's a fairly fluid situation right now, and a lot of it really does depend on how issuers respond to these resolutions.
Thanks, Pat. Turning then to shareholder proposals, the next slide here shows the top 10 proposals that were submitted last year, along with the number that were actually voted on. As you can see on several of them, and we'll go through each of them here, a number of them do end up getting settled and not voted on, and that is a strategy that companies can often use on a number of these to come up with something in the middle that works for both the investors and the company. Just because you receive a proposal asking for something doesn't mean that there isn't room to talk with the proponent on it and negotiate a settlement that's appropriate for both the company and the investors. The largest number of shareholder proposals last year were submitted on political contribution and lobbying payment reports. They tend to get relatively low support, as you can see here, but we certainly expect this to be an area where there will continue to be a number of proposals, particularly in the currently politically charged environment. ISS has made a slight change in how it reviews these, and Pat will be talking about that a little later in our presentation. Another large area for shareholder proposals, which continues to be at the center of investor attention, is splitting chairman and CEO. You see here that in the past, ISS has recommended for and against at companies at a relatively even clip. This is another area where ISS has changed its policy, and Pat will again be talking on that in more detail. But this is certainly always a proposal where a company gets it that is a sensitive one to think about. CEOs usually do not want to see their role split. Majority voting standard for director elections. This has been a top proposal now for a number of years. Another area where companies have settled in a number of cases, and that these often don't always go to a vote. I think it's useful to note here on the next slide where we currently stand on this. Majority vote has clearly become the standard at S&P 500 companies. Still not yet the majority at Russell 3000 companies, but as shareholder proposals continue to work their way down the chain to smaller cap companies, we would expect to see that number increase as well. Reports on sustainability. This is particularly an area where I've seen settlements be able to be worked out often. When these do go to a vote, they get a relatively low vote, but it is an area where you can settle without too much effort, depending on the nature of the proposal and the proponent who has provided it. Action by written consent. This is one of the rare areas in the takeover defense type of proposals where the support for these has been declining over time. If you have one of these proposals, how successful the company will be on it will depend in part on the rest of its governance profile. Of particular importance is whether the company allows shareholders the right to call a special meeting. If a company does do that and does it at an appropriate threshold, this is a proposal that can often be defeated. Stock retention and holding period proposals continue to be out there along with other compensation. but these types of proposals, support for them is typically low compared to your takeover and other governance type of proposals. Elimination of classified boards is a proposal. This is one that is always successful for the proponent. Last year averaged 83% for. Over the last few years, there have been a large number of companies that have received this proposal. 85% of them have settled and put in place a process to declassify the board. It's important to note here, if you get one of these proposals and you do want to agree to declassify your board, you don't have to agree to do it immediately at the first meeting. It can be done over time. Will usually be agreed to by the proponents. We talked about a little bit calling of a special meeting and the action by written consent. Here is an area where, similar to what we're seeing on Proxy Access potentially, where when companies have received this, management has sometimes been proactive to submit its own proposal to then be able to exclude the one from the proponent. Management proposals typically have been at the 25 threshold, whereas proponents are typically looking for something lower, 10 or 15%. Report on board diversity was submitted at a number of companies last year. Typically doesn't get a real high vote, and a lot of them do get settled. I know that there are a number of those proposals out there this year. Eliminating supermajority provisions is another area that continues to be a focus and receive very high votes, and as a result, a number of these often do get settled. And then the other area that I would put out there that we certainly are seeing a number of this year is other types of compensation-related proposals on prohibiting tax gross-ups. The AFL-CIO has had a letter writing campaign to get companies to agree to not put in place gross-ups, otherwise threatening shareholder proposal on it. Expect that a number of companies will be agreeing to that without even going to a proposal that's voted on, in light of the fact that if a company does put in place new gross-ups, that can have very adverse consequences on, say, on pay vote. With that, I'd like to ask Pat, other than Proxy Access, what are you seeing this year? Any new topics that people should be on the lookout for?
Well, I don't expect, other than obviously Access, any issue to crack the top 10 this year. I think a lot of those perennial proposals will remain showing up in corporate hoppers in significant numbers. I think, and obviously the negotiation process is something that really affects how many end up showing up on ballots, as well as the no action process. I think just for some, winners and losers year over year, I think probably I see the independent chair proposals remain fairly constant over time. I think despite the fact they really didn't see any significant increase in shareholder support year over year, and it actually went down a little bit, I think. But I don't expect to see a big drop-off there. It tends to be a popular topic for some of the activist asset owners in particular, and so despite the small percentage, at least, the majority votes on the topic, don't expect those to drop off. I think the accelerated vesting issue on your last slide there, that's one I think that's going to be in the ascendancy given the majority votes, which were in a first-time event on that topic last season, I think, and so we could see some trade-off between that issue, for example, and the holding period resolutions that, as you mentioned, don't get quite as much support, I think. And a lot of those perennial proposals on takeover defenses, declassification, supermajority votes, and written consent actually could be down a little bit, I think, as more of the pressure really steps up on issues like proxy access from some of the gadfly investors who've been offering those proposals. And frankly, as the number of targets within the S&P 500 continue to plummet given the adoption of reforms by boards. A couple issues to look out for, but they're not going to show up in huge numbers. One is request for risk committees. with the burgeoning number of data breaches, cybersecurity, and other risk areas, I think are becoming top of mind for many boards these days. And we're going to see a series of shareholder proposals, assuming they clear the hurdles at the SEC, showing up asking some companies' boards to consider adopting risk committees and to separate that function out from the audit panel or wherever else it's being handled in the board of directors. On the environmental side, and if you combine all those proposals on climate change and climate risk, they were actually in the ascendancy last year. They were well up our list of the top 10 overall topics showing up on boards. And this year we have an interesting hybrid that brings sort of greenhouse gas emission reduction goals and executive compensation together, and in asking companies to put some goals in place on the comp side for CEOs to make sure that they're meeting some of those GHG reduction levels. And corporate taxes, inversions have been in the news. Other tax avoidance schemes over in Europe in particular have gotten scrutiny from regulators and from the media. We expect to see a number of shareholder resolutions on ballots this year asking companies about the corporate reputational effects of taking advantage of those tax avoidance strategies. So a couple new topics that, again, won't show up in significant number, but I think they're sort of trial balloons going out this year, and the proponents hope to see what sort of traction they get, and we could see more of them in the future if they win some substantial support.
Thanks, Pat. Rick, any words of advice to companies on how to deal with shareholder proposals, whether to settle or fight, and how one goes about that? Do we have Rick on?
Sorry about that. I was on mute. First, as soon as you get the proposal, you have to understand, of course, what how your shareholders vote on this proposal historically. You can look historically on, there are proposals that garner significant support, but it is possible that your shareholder base actually may vote against that proposal. But there are several proposals out there, like the anti-takeover ones and the majority vote proposal, that for some companies it's just impossible to be able to defeat that proposal. So obviously it's wise to negotiate, settle, and then the other issue, as I mentioned before on the proxy access, is whether or not we're going to deal with proxy access by companies adopting their own and coming forward with their own thresholds to receive the no action relief. So it's yet to be seen. We don't know whether there's going to be too many companies that are just going to embrace the proxy access number at 3 and 3, but yet to be seen.
All right. Let's turn then to a brief discussion on increasing shareholder activism, putting aside shareholder proposals, which is obviously one form of that, but talking more about what I would call real shareholder activism. The trends on this continue to exponentially increase. Activist funds are continuing to proliferate, more new ones every year, with over $100 billion in assets under management. During 2014, there were over 350 campaigns at different companies, and certainly no one is safe anymore. Targets include large cap brand name companies, Apple, Microsoft, PepsiCo, Walgreens, DuPont. The activists are obtaining support from institutional investors in these campaigns as well. They have also partnered with strategic bidders during the past year, and settlements granting dissidents a board seat have become common at larger companies. The statistics for last year was that the activist won either by ultimately going to a shareholder vote or having a settlement in 72% of the proxy fights, which when you think about it means it can be a very uphill battle for a company. Certainly there are some things that companies can do to stay off the watch list of activists, probably most importantly having good stock performance, but that's always not within your control. Other things to be doing include keeping the board refreshed. If all the directors are long tenured, that will be an easy target if an activist shows up. Also want to stay engaged with shareholders throughout the year, explaining your strategy to them, explaining your results if there's a shortfall. Companies should be continually reviewing their corporate strategy. Are there underperforming businesses that perhaps they should divest? Do they have the right capital allocation strategy? Also, obviously want to be watching all the usual corporate governance and executive compensation matters so that activists don't have something easy to latch onto. Pat, do you expect to see this activist fund challenges at boards continue to spread? How far can it go?
That's, I guess the sky's the limit at this point in time. They continue to add additional assets in the activist hedge fund space. They crossed the $100 billion threshold last year, I think, and sort of the end is still not in sight at this point in time. So we're just seeing a lot of new funds that are springing up, some of them starting to target micro cap, middle market, large cap, as you talked about before with some of the big brand name companies. So I think you're absolutely right. No one is safe these days, I think, and I think some of the prescriptions you laid out there about looking at your own business as an activist would, and as portfolio managers do at the large voting institutions, that's, I think, the key to sort of avoiding problems. The tactics are picking up, though. If you look at the quote-unquote a vicious attack video put out by Dan Loeb and Third Point at Dow Chemical recently, I think that was a big reason why the company ended up settling, even though there was a lot of distance between what Loeb was asking for and what they see as the future strategy for the company. And I think part of that was they wanted to get a non-disparagement arrangement in place and get the website and the video taken down, I think. And so the tactics for some of the activists are getting really edgy now, I think, and with not only corporate executives but board members' reputations on the line, I think there is a strong urge to settle these days. And I guess I'd offer one caution there, and I think sometimes companies need to go out and talk to their institutional investors before they go ahead and settle, because some of these, I think, knee-jerk settlements quite often end up raising as many questions with institutional investors as they answer, simply because they're sort of wondering why there was sometimes a disproportionate amount of board seats handed over to a dissident in these situations when there may be some strong disagreements over strategy in the investment community generally. But they're here to stay, they're growing, and they're not going away. So I think companies really need to come up with strategies to address them, both before they occur and then after the activist knocks on the door.
Thanks, Pat. Rick, given they're not going away, some thoughts on how companies can best deal with these challenges, either in advance or once they have popped up?
Right. I guess, as you said, every company kind of now needs an action plan because everybody is a potential target. The biggest thing is don't get caught flat-footed. It is you got to hit it head on. I can't tell you how many times when an activist comes out and is raising issues, companies say that some of their large investors have been raising those issues for the last year or so. And these are issues that have to be addressed head on, because if an institution is willing to tell an issuer about their frustration, they're also willing to tell other investors and activists about their frustrations. So you cannot bury your head in the sand on these issues anymore. And I think what we're going to do is we're going to start seeing more and more disclosure by companies of sort of getting out in front of their capital allocation strategies and things, because it is we're seeing more and more of these come out, and companies are just unprepared to address it head on with their investors. So, and then the other issue I would just add is you really got to know your investors. You got to realize some of these activists are meeting with the institutional investors 2-3 times a year because of proxy campaigns that they're doing. And for you to meet with them only in an event of a crisis, it is not a level playing field anymore.
Thanks. Let's now turn over to what's become such an important part of the proxy season, a discussion on executive compensation and say on pay. I'll turn it over to my colleague Josh.
Thanks, John. So first I'd like to just do a little recap of the 2014 results in say on pay. The overall results were similar to 2013, although of course results for individual companies varied quite a bit. Average support was about 92% if you look at all of the Russell 3000. There were about 2.5% of companies, or about 55 companies, that had a failed say on pay vote that received less than 50%. One thing that was notable in 2014 was that the shareholder engagement and kind of remedial measures that companies took after they received a failed vote in 2013 seemed to work, since a majority of those companies were back above the 70% support mark in 2014. There did continue to be a correlation between negative vote recommendations from proxy advisors, ISS and Glass Lewis, and failed say on pay votes. The correlation maybe was a little less strong than in prior years, but not really a big difference there. There's definitely a strong correlation. The negative vote recommendation from ISS in 2014 would have been correlated to a decline of about 26% in support for say on pay, so that is a significant consideration. Some of the most common reasons for failed say on pay votes were the pay and performance disconnect. That's really a measure of the CEO's compensation versus the relative TSR performance of the company. Are the two moving together or not? If not, you've got a potential pay and performance disconnect. Poor stock performance, for companies that are really troubled or really struggling in performance, it can kind of lead to a dynamic of shareholders generally being a bit disgruntled and willing to consider, or more willing to consider, a vote against the CEO pay. Insufficiently rigorous performance goals was another factor that turned up frequently as a complaint. And then special awards, mega grants, or non-performance-based equity. If it's a disproportionately large part of compensation, those are also factors associated with failed say on pay votes. And then the problematic pay practices, things like excessive perquisites, severance of more than 3 times base and bonus, a liberal change of control definition, excessive gross ups for taxes. Those are all considered problematic pay practices that could contribute to a negative vote recommendation and then potentially a failed say on pay vote. These factors are not always kind of isolated. A lot of times companies with failed say on pay votes had multiple factors present, but the factors that were present in failed say on pay vote remained remarkably consistent from over the last couple of years. So I guess maybe in looking ahead to 2015, the takeaway would be, if you have any of these elements present in your compensation practices, consider being very proactive about addressing them through disclosure, through shareholder engagement, or doing substantive changes if you really anticipate problems, to try to sort of head that off. The forecast for 2015, there weren't any major changes in ISS's policies relating to say on pay. Glass Lewis made a couple of changes that we'll talk about more later. They're going to look more closely at one-time awards, and they have instituted kind of a quality control measure. And looking at clawbacks, they want to see certain elements present if you institute a clawback to give you credit for that. There's been some speculation you might see some companies hold the say when on pay frequency vote early. This was, if you remember, in 2011, the first year of say on pay, there was also a required vote on say on pay frequency, and that was called the say when on pay vote. It could either be every year, every other year, or every 3 years that you'd hold the say on pay vote, and the board would make a recommendation typically, and then shareholders would vote in an advisory vote on how frequently they wanted say on pay to happen. The next vote on frequency is not required until 2016, but I guess there's been a little speculation. Some people, if they think it's become so routine, particularly if they've had good success every year, they may want to move to a triennial frequency rather than an annual frequency, or in some cases vice versa, just depending on the circumstances of the company. There might be a thought of why wait until you have to do it, could do it early. So I guess I'd like to ask Rick, where do you see Say on Pay headed in 2015? Is it going to be a repeat of last year?
Yeah, we're not expecting significant changes. I mean, what we believe is, companies unfortunately fall into a lull that they've had a number of years that they're, receiving 98% support, and then they've got nothing to worry about. The reality is every company needs to worry about it every year, and have the game plan in place to combat a negative Say on Pay recommendation by one of the proxy advisory firms, which requires being prepared to take your message directly to the shareholders. Many times in the face of a negative recommendation by one of the proxy advisory firms, companies can mount a great campaign and get incredible support from their investors, but it requires an outreach. Also, I'd like to add that the team has changed when it comes to who is part of that outreach. Investors now expect to see a member of the comp committee in these meetings and on the phone when there is a comp-related issue, as well as the head of HR is taking a much more active role. And companies really need to, every year, sort of have their bullet points already in place on potential comp changes that they've made to be able to, address this head on with their investors. But with the right plan in place, companies can still garner decent support with Say on Pay, even in the face of proxy advisory firms' negative recommendations.
Thanks. Pat, do you expect to see more Nay on Pay campaigns for board elections in 2015?
I'm not sure about more of them, but we're still going to see them. For those of the listeners that aren't aware of the phenomenon, it just sort of amped up the traditional Say on Pay advisory vote by combining a vote against members of compensation committees, typically the chair or all the members of that panel, along with a public urging via an exempt solicitation or just letters or other factors against the Say on Pay vote itself. Obviously, results matter, and there was one company, Chipotle Mexican Grill, where the Say on Pay vote was knocked down, and the equity plan actually failed as well. That was targeted by CTW. Their broader campaign focusing on fast food / quick service or restaurant businesses, I think in many ways sort of focusing in on the growing gap between not only CEO pay but senior executive pay generally, and sort of rank and file workers along the lines of the whole pay ratio notion. But it didn't get traction outside of Chipotle to a very significant degree at some of the firms. I think we'll see some different targeting perhaps by CTW this year, but they're also expanding their no-vote campaigns against boards to hit risk oversight failures and other things that have perhaps tapped more into shareholders' hotspots when it comes to voting in prior to the 2014 proxy season. So not more, but it's a tactic that's out there to stay. And interestingly, we also saw low votes on Say on Pay showing up as one of the targeting factors for New York City in their Proxy Access campaign. So there's now sort of a double whammy out there that potentially a high negative vote on Say on Pay could be a magnet for attracting one of those Proxy Access resolutions to your meeting. So something else to watch out for issuers in the future.
Thanks, Pat. Next, just a minute or two on some disclosure trends and considerations in the area of Say on Pay as everyone's kind of ramping up, preparing their proxy statements again. Thought it was worth just kind of mentioning some of these trends. So pay for performance disclosure tends to be an area where you see a lot of extra voluntary compliance. I think that trend has been continuing. Voluntary extra disclosure. You see that trend continuing. There's no requirement to disclose specifically pay for performance under the current securities laws, although Dodd-Frank requires the SEC to eventually promulgate rules that will require that. They haven't come out yet, but it's more part of this kind of sales effort or communications effort to shareholders about pay practices and to get support for Say on Pay, that companies have been including disclosure showing the relationship between pay and performance in their CDNAs. So a lot of a common type of presentation is you'll see the pay map, the realizable pay or realized pay map against performance, and those two kinds of pay disclosure differ from the summary compensation table pay numbers, in that realizable pay would value equity-based awards based on the value of the stock price at the end of the year, rather than in the summary compensation table you have to show those at the grant date fair value, kind of that accounting value. Or some companies will use realized pay, which is, again, the only difference from summary compensation table is in the value of the equity. Realized pay would value the equity based on, did any shares vest during the year, were any options exercised, and if so, what was the value realized on that equity, and that would be the value of the equity for that purpose. A lot of use of charts and other graphics in showing pay for performance. Location of the proxy statement, I think most companies probably are putting it in the CDNA rather than with the Say on Pay proposal itself. One consideration is, are you establishing a workable precedent if you're going to include disclosure on pay for performance? Are you, picking and choosing? We have one great year as measured by one performance measure. Is that something that you'll be able to continue to use in future years? I think investors are wary if you keep changing the story every time or changing the kind of measurements every year. Keep in mind, if you do include pay for performance disclosure, some SEC requirements. If you're going to use a non-GAAP measure, you've got to comply with the non-GAAP reconciliation rules in the proxy statement. Also, the overall consideration of it not being materially misleading if you're using a non-GAAP measure applies. Continuing trend to see in CDNA, you see executive summaries and lists of best practices. I think more companies are also including a proxy summary at the beginning of the proxy statement, just to try, kind of acknowledging people don't read the entire proxy statement. Giving them just an executive summary in the first few pages can be very helpful. Sometimes overlooked required disclosures in CDNA discuss the prior year's Say on Pay vote and how you responded to it, even if you had a good outcome. Disclose the frequency of your Say on Pay votes and when the next vote will occur. And then I think some companies have begun to include a pay ratio disclosure on a voluntary basis. Pat alluded to it earlier. This is showing the ratio of the CEO's pay to the median employee's pay, or the ratio of the CEO's pay to the pay of the other named executive officers. And so Dodd-Frank is going to eventually require companies to include the ratio of the CEO pay to the median employee's pay, and I'm going to talk about that shortly. But some companies, I think, are including a voluntary version of that early, and some of them are doing CEO pay versus named executive officer pay, because I think that's considered by some to be the more relevant pay measure. Just to talk about that pay ratio requirement under Dodd-Frank, the requirement will be to disclose a ratio in the proxy statement showing the relationship of the CEO's total compensation with the total compensation of the median employee of the issuer. The SEC proposed rules on this in September 2013, but the final rules have been delayed and now are expected maybe in October of 2015. So something on the horizon, but not an immediate requirement. Under the proposed version of the rules, there was a little bit of, identifying the median employee might be challenging, particularly for international employees with multiple international employers with multiple payroll systems. But you could use different measures of compensation to identify the median employee or statistical sampling. So there were some elements of the proposed rules that would make compliance a bit easier. With that, I will hand it over to Pat to talk about changes in ISS's voting policies.
Great, thanks a lot. I think as you previewed before, I think the independent chair issue is one where we made a change in policy year over year. I think despite the sort of the common wisdom out in the marketplace, we only supported around half of the investor calls via the shareholder resolution process to move to an independent chair structure during the 2014 proxy season. And we've been actually splitting our recommendations pretty close to 60-40, 50-50 over the last couple of years. The bulk of our old policy was driven by whether a company had a meaningful lead director position in place. I think and then if they didn't have any sort of overwhelming problems on the governance or performance front, chances are they would get a wave through if they had a strong governance structure. Otherwise, I think what happened was many issuers were sort of tailoring their response to these proposals to the test itself, if you would. I think adopting stronger lead director positions without necessarily addressing why they had adopted the leadership structure that they had in place at that given point in time. So by switching to a more holistic approach, our analysts will really be able to delve into those why issues, why the company has adopted the leadership structure that is put into place and at this point in time, and how that fits into the overall notion of board leadership at the firm and how it's evolved over time. What we've been seeing recently in some situations, B of A, the most notable one recently is companies sort of jumping back and forth between independent chair, lead director, combined CEO structures without a great deal of explanation. It seems to be driven more quite often by executive succession planning than by board succession planning. And we're hoping that generally the disclosures and the tenor of debate around these issues shift more to a broader discussion of what's the right board leadership structure for the company at that point in time, I think, and that's what our analysts will be looking for. But I think it's still going to be clearly a case-by-case analysis. It's not going to be, however, driven by the lead director duties as it has been driven in the past, although they remain important to the analysis. Next up, I think, is unilateral bylaw and charter amendments. This has become a big issue of concern for our institutional investor clients. We literally tracked a 5-fold increase year over year in the number of boards that had adopted non-shareholder approved guidelines. And while some of these companies were in pre-IPO stage, and it's really more than about disclosure to shareholders in the prospectus of what these bylaw and governance provisions are going to be than it is an accountability issue on an immediate basis. But there were a significant number of companies, and I mentioned B of A because that's how they changed from their independent chair structure to the lead director, and combining the CEO and chairman position was to repeal a shareholder-adopted bylaw and unilaterally adopt their own bylaw dealing with the lead director structure. And so I think what we're going to see more often going forward is a discussion and debate by institutional investors about boards that are taking actions on material issues that impact shareholder rights without going to investors for a vote. And the factors listed on the slide here are some of the ones that we'll look at in making recommendations on directors when those unilateral bylaws are put into place. I think that's something for boards to, I think, include in their process of looking at bylaw issues is, sort of how it's going to impact shareholders' fundamental rights to sell their shares, to vote their stock, or, and moving to the next slide, to sue the company. Obviously, we've seen a lot of hubbub recently about not just fee shifting, but exclusive venue bylaws as well. Most of these have been adopted by boards without giving shareholders the opportunity to vote on them. a Delaware court case, at least for a private company, seemed to open up the doors to fee-shifting bylaws to be adopted. This is something that I think investors are looking at right now and are likely to take action against some boards, at least for some investors. What we found generally is for the very strict fee-shifting resolutions, which tends to be the form that most companies have adopted debate, there seems to be general shareholder antipathy towards them based upon the fact that it really does significantly raise the burden of bringing litigation, and given that some of these rules require that the plaintiffs be 100% completely successful in all their claims in order to avoid fee shifting, it does become something that I think a lot of investors view as being potentially a bar to shareholders bringing litigation generally. But our policy's laid out there, and I think we're going to go to our polling question now.
Thank you, Pat. So at this time, I'm going to read the CLE code for this program. If you're in need of CLE credit today, please enter this 4-digit code into the poll question on the screen after it's announced and press the submit button. The code is YI6N. Again, that's the letter Y, the letter I, the number 6, and the letter N as in Nancy. Again, if you are seeking CLE credit for this session, please complete the polling question by entering the code that was just announced. The polling question will remain open briefly. For those seeking Kansas, New York, and New Jersey CLE credit, in addition to answering the polling question, you will need to complete the attorney affirmation form and return it immediately following the program. A copy of the form can be found in the resource list widget. So at this time, the poll is now closed, and I'd like to return the program to our speakers.
Great. Just moving on to ENS, that is Environmental and Social Proposals now. The changes we made on the political contribution resolutions, and we talked about the significant numbers of those showing up on ballots and the fact that they may pick up in a pre-presidential election year. It's not a significant change. It was really more taking into account how we had been evaluating these proposals generally already, I think. And so we will just be reviewing and considering board and management oversight mechanisms in applying the policy. And on greenhouse gas emission reduction goals, I think, again, this was another case where we're pretty much trying to create complete transparency over our process of analyzing these resolutions by clarifying the factors that we look at in that analysis. So no real significant shift there, but just some additional guidance in the policy as to what factors we're weighing and what sort of weight that we're giving to them, I think. And then finally, our equity plan scorecard is probably the biggest change for the year, I think, and I don't want to take up the remainder of the webcast talking about it. There's a lot of information at our website at issgovernance.com, including some white papers and other documents that will help you wade through the changes year over year. But suffice it to say, we've moved from a series of pass-fail tests related to equity compensation plans to more of a holistic examination that will weigh factors related to the plan's costs, the plan features, and also grant practices. This is I think a development which has been fueled by feedback from our institutional investor clients in recent years, with the changes in equity-based compensation plans being driven by not only the say on pay, but by accounting changes as well. We're seeing a lot more performance shares and performance-based equity plans, and as a result, I think grant practices and plan features have taken on added value to institutional investors in voting on these resolutions. I think the slides here sort of lay out the various costs of plan features and grant practices that we're looking at, but suffice it to say, plan costs will remain sort of the biggest part of the pie, if you would, for our analysts in making their final recommendations. But unlike in past years, falling slightly below our allowable cap will not be a guarantee of support, and getting slightly above our allowable cap will not be necessarily the deciding factor in our recommendation. Instead, we're going to spend a lot more time looking at the plan features and grant practices as potentially mitigators in making our final recommendation to clients. I think again, just more detail included here in the slide about how we're going to apply the policy, but suffice it to say, it's something that we're going to be very dependent upon better disclosure by corporate issuers. In that regard, we have a data verification process that you can go through for equity-based compensation programs that you can find at that same issgovernance.com website I talked about before, which hopefully will give issuers some time to provide the latest and best information to our analysts as they're looking at the cost and the features of these programs.
Thanks, Pat. Just to run through Glass Lewis's changes for 2015 quickly, or at least the ones we thought were worth highlighting. They've got a separate kind of governance committee vote recommendation policy. They'll recommend a vote against the chairman or the full committee if the board unilaterally amends governance documents in a way that removes important shareholder rights or impedes the ability of shareholders to exercise those rights. They'll also recommend a vote against the full committee if the board doesn't respond adequately to shareholder proposals relating to important shareholder rights, things like declassifying the board or majority vote, right to call a special meeting. The second one relates to director independence. In assessing the director's independence, Glass Lewis will look at material relationships with the company. Generally, they apply a $120,000 threshold to that, but there's an exception that they're adding or clarifying that $120,000 is not automatically material if that's a very small percentage of the director's firm's annual revenue, and if there's disclosure of a compelling rationale as to why the director's independence isn't affected by that relationship. The third one we wanted to highlight, it was just the one I mentioned earlier. Glass Lewis is going to, in making its recommendation on say on pay, look more closely at what they call one-off awards. Just these are awards outside of the ordinary course incentive programs. They want to see certain disclosure and performance elements in any one-off awards when they're looking at those, or presumably they'll factor them in negatively in their say on pay vote recommendation, and they'll consider the terms and the size of the grants in context, as well as how the company's kind of doing on a performance basis. That'll hand back to John for our last topic.
Josh. And before turning to the last slide here, Rick, of all these proxy advisory firm changes, any of these that you see as having a real big impact from the company's perspective?
Well, I do. I mean, look, obviously the comp changes are huge, but the unilateral bylaw proposal, policy shift is a game changer on the way the board takes action going forward. So I do think that although it doesn't affect a tremendous amount of companies, it does make significant changes for those, and many of those are involved in potential activism events. Also, I would say just the issuers have always been critical of the policy for independent board chair, just because they always felt it was just too prescriptive. But now they're equally as concerned over the new holistic approach, where at least under the old policy, companies could get a good understanding of whether or not they were going to get a for or against recommendation from ISS leading into the proxy campaign. And since, of course, the independent board chair proposal hits home at many companies, knowing, getting some knowledge that ISS would be supportive can direct sort of the solicitation campaign.
And I certainly agree with that last point. CEOs do not like uncertainty. Turning here to the last slide then, we just thought we would note some trends and actions that companies voluntarily, even without shareholder proposals, that some companies have been doing. Certainly there's no one right answer for each company. Different issues have different levels of sensitivity at different companies. But at companies where there's been a failed say-on-pay vote or other governance issues, or they have real low corporate governance scores and are looking to improve them, we've listed here some of the common ones that we have seen companies do. Some maybe, as we say here, low-hanging fruit, adding anti-hedging or pledging policies, clawback policies if you don't have one, even though they're not yet required, enhancing stock ownership guidelines, eliminating tax gross-ups, more on the governance side. This ties back into the activism discussion as well, adding new director candidates to refresh the board or to diversify it. If a company has a rights plan in place, there's still a few left yet from back before ISS changed its policy. People are letting those expire as they come to their terms. There are then more potentially difficult changes that certainly on the comp side raise more sensitive issues with executives and the like, but that some companies have looked at, such as changing to a double trigger vesting instead of single trigger on change of control, or adding equity holding policies, adopting majority vote and eliminating classified board, are some other areas in light of sooner or later a company may get a shareholder proposal on those. I think with that, Ellie, I will turn it back to you as we are out of time. People who have submitted questions, we will try to follow up with those people in writing. Thanks again, everyone, for participating.
Thanks, John. So we invite you to contact any of today's speakers if you have additional questions or would like more information on their particular topics. And as John said, we'll follow up with anybody who had written questions after the program. So this wraps up our web conference today. So just as a reminder, today's program is being recorded and then will be available on Foley's website in the next few days. If you have questions regarding CLE for this program, please contact Ellie Kemeter at ekemmeter@foley.com. And at the conclusion of the program, a questionnaire will appear. Please take a minute or two to give us your feedback about the presentation today. It's important for us to know your thoughts and helps us shape our programs going forward. Thank you again for your participation.